Good evening, everyone, and welcome to the first installment of Operation Safe Spaces Family Law Seminar. My name is Robin Paris, and I am one of the project managers with OSS. And on behalf of the team, I would like to thank you all for joining us this evening. I'd like to go ahead and introduce today's presenter, Mr. Rashad Brathwaite, attorney at law and academic. Rashad is, for those of you who don't know him, Rashad is the Junior Research Fellow at the Faculty of Law of the University of the West Indies Cave Hill campus. And we appreciate Rashad this evening for agreeing to lead us through a two-part introduction to gender-based violence. There are a couple of quick housekeeping notes before we begin. This will be an interactive presentation, and Rashad will pose questions during the presentation, at which point you will be asked to unmute your mics and participate. However, apart from these, we ask that you be mindful that your audio is muted during his presentation. There will also be a 20 to 30-minute question and answer session at the end of the presentation. And during this time, you may pose your questions by raising your hand using the reaction button or to type into the chat. We are also, as you will note, recording this seminar, and we will be providing a link to download the seminar following the conclusion of tonight's event within 24 hours by email. And if you haven't done so already, we would love for you to check us out on Instagram or Facebook at oss.246 to learn more about the organization and all that we have in store. Again, for anyone who's just joining us, this is our first installment, Module 1, which is the first part of a two-part introduction to gender-based violence. And without further delay, I'd like to hand the controls over to Rashad. Rashad, over to you.
Hi, good evening, everyone. Let me pop my camera on for you, and you should be able to see me now. So it is my privilege really to be with you this afternoon into evening, as we explore what is an important and necessary area of law, but more broadly, and my presentation today and into Thursday covers that intersection then between law and what is then a societal phenomenon that we are interested in tackling and eradicating from the social landscape of Barbados and the region by extension. So again, thank you, Robin and Operation Safe Space, Marcia, and others for allowing me to be a part of this important work. So I'm going to start to share my screen, and I see some names and a few faces that I recognize, which is usually both exciting and terrifying all at once. Good evening to those. Some of you I've taught before, some are colleagues. I want to say maybe even some who may have taught me. So I'm going to now begin to share my screen and just arrange then for everything. So there is no smooth way for this one part of Zoom. So just give me 1 second and we will start with that. But what we can't do in the interim, just so that we're familiar with each other, and you're going to be on this journey for a little bit longer than my session, being a part of the full 20-hour training program. Feel free to pop just a brief introduction into the chat, because we're definitely not going to have everyone be able to introduce themselves, but it's useful then to, if you could just pop your name into the chat, your area, if you're a young attorney, if you're a student, just so we know the breadth of experience in the room. but at some point I will engage participants a little directly around icebreaker, just because even in the Zoom format, it helps to have some points of familiarity. So feel free to pop those into the chat and just fixing one thing I'm just noticing, and we will be on our way. And for some of you who are familiar to the gender space, then some of this will be sort of rudimentary, some of it will be familiar, but it is all necessary in us then being able to work through our understandings of violence against women as a form of gender-based violence. You know, what do we mean when we talk about gender-based violence? Why this reference to gender-based violence? And you'll notice from Operation Safe Space, we're very specifically then focused on the state and the interaction with female victims, even as we are aware that intimate partner violence is not exclusively experienced by women. So why this focus on women? And at the start, we'll say that that is an important and specific and intentional focus. So now that I think we have sorted everything that we wanted to, then I will be able to get this shared with you. And let me know whether you're hearing me clearly, if there's any issues. All right, so lovely. All right, and everyone is seeing clearly. All right, so what are we going to be doing today? We're going to be defining some of the key terms. We'll try to have a sound understanding of the types of gender-based violence. So before that, of course, what's the scope of gender-based violence? And then what relationship for law? Why is the law engaging around this in circumstances where historically, and I'm grateful that this is perhaps lesser a view held now, even though that there may be some pockets of perspective for this idea then that this was not an area for law's intervention, that's man and woman business, let's not get involved. What role for the law, and how has the law potentially been developed for use in this area, and what are some of the underexplored avenues that international human rights law or constitutional human rights law, how might they be brought to bear in what we will be addressing? So you'll see a little bitmoji of myself, and you may see Leah Thompson, who works with me in this area. We're both members of Caribono, which is a pro bono volunteer network of attorneys, very much a baby organization, and we tend to work together in this area. So Leah may pop in, but I certainly will be here for the entirety of this session and on Thursday. So usually I like to set some guides to engagement so that we're all comfortable with each other, and we try to make this a safe space, but also a space where we feel as though we can have constructive dialogue and share differences of opinion. And so it's important then that we engage the conversation as one of mutual respect. Of course, we maintain confidentiality. So, where we may be talking about a relevant experience, we want to make sure that that's being expressed in a way that maintains the confidentiality and integrity. But also then that if there are some experiences which come out in this conversation, which might be personal, for example, that we do want to maintain some level of confidentiality so that persons feel safe in being able to have these conversations. Then of course this requires an empathetic approach to justice. And so how we engage with each other, empathy is an important part of that. But of course, there's always the need for us to be interested and engaging. And so vibes is my broad caption, because I know that in a virtual environment, you know, far be it even the physical environment, that any 2-hour session can be difficult. And at the end of the working day, we're tired, etc. And so my approach to engaging with you is that I try to engage you in some direct form of questioning every 10 to 15 minutes. Just good pedagogy tells us that after a while, I will be fighting you for sleep if we're not engaged a bit more. So those are rules for engagement. And just broadly then, we want to strengthen our knowledge on gender-based violence and then domestic and international law. So now to jump into the meat of the matter, and before I do that, let me just check the chat. So I am seeing quite a number of colleagues I've worked directly with, a variety of areas. So you'll see then that we have students, we have attorneys who are under 15 years call, some up to 34 years call, some freshly admitted to the bar, and so welcome. And for those who may have not long received news of your successful taking of the final year of law school exams, congrats and welcome. You will have an interesting experience ahead of you. So we're not going to go into breakout rooms for this, but I do want you to pop into the chat. What's driving your presence here today? So for those of you who've been working professionally in the space, what are some of the experiences that point you to say, I want to know more about this area? And for those of you who may be new to practice, perhaps experiences, they may be personal, they may be experiences of friends. What are some of the experiences that draw you towards being a part of this conversation? And it's useful for us to share some of those experiences, because we'll then be able to connect those directly with some of the definitions that we will be taking. So what I'll do is I will invite participants to pop into the chat, but I'll take about 3 comments. So what are some of the factors, what are some of the experiences driving your presence here? So I'll take 3 participant responses, and then we'll see some in the chat, and then we'll move on to the next area. So I'll give you about 30 seconds to get comfortable. You can raise your hand. If not, then I'll pop into the chat and call names that I'm familiar with. And I'm flagging then that if I know you personally and you have a picture, you're probably going to be first up on the list. So Nyla.
Hi, Rashad.
Hi, Nyla.
Well, I have had a general interest in this area. I've also been teaching part-time, so I engage my students and make sure that they are all up to date on the general issue so that when they go into practice, they will be more aware and sensitive. I've also had the experience of seeing the system go horribly wrong. Sorry about the background noise.
Yeah,
And always
we're
work.
all working from home, so
Yeah. Yes, but and seeing the same players start to improve themselves. So I had a case where, you know, one day a magistrate did some mediation instead of actually making a protection order, and over the weekend, the perpetrator horribly attacked the victims the weekend right after. And that was a very eye-opening experience. Since then, I have seen a huge change in that particular magistrate, where he's taken things far more seriously. And for myself, I've also taken the area more seriously.
Thank you so much, Nyla. And a couple of points there that we want to touch on because we'll be coming back to them, right? And so at least historically, and it may be the experience still, you had a sense within the judiciary that, you know, this being a softer area of law, that this was perhaps an area where, you know, we could engage in some basic level mediation, and the protections that are intended by the law, that those may take a secondary position because we're dealing with man and woman business, because we're dealing with questions of the heart, etc. In circumstances where often that has resulted in significant harm because the very thing that the legislation was seeking to protect had been sidestepped. And there is a case that I'll share briefly before we move on to the other participants. I'll just take two more, where in that case, having gone to the police and the police not having taken statements on 6 of the 7 occasions that the individual visited the police station, and having gone to the magistrate court for the protection order, the magistrate said, you know, this is a nice looking, well-behaved, decent young man. He couldn't do these things. Of course, having not had the benefit of the protection order, etc., the results were harrowing, where having been denied the protection of the law, then that gentleman would have engaged in serious, initially life-threatening violence and ultimately fatal violence. And so we appreciate the importance then of treating this as an area that involves the protection of the law, that involves the necessity of the state providing equal protection of the law. And I'm speaking to a Barbadian audience. We're going to talk a little bit about the protection of the law as has been developed by the Caribbean Court of Justice, and what that potentially means for how we hold state actors accountable. So in the case of where Nyla had mentioned in the example that I provided, what happens, how do we respond when state actors have failed to fulfill their duties? Thankfully, we're seeing some developments in the law that point to the possibilities of accountability. But of course, the reason that Operation Safe Space and others working in the area exists is not for accountability. We want that these matters are treated too properly in the first place, and so prevented. But in the event that they are not satisfactorily dealt with, we want to be able to have mechanisms for accountability. So I will take one more. Let's see, any volunteers before I call Lani?
Hi, Rashad.
Hi, Lani.
How are you doing?
I'm well, thanks. There being no volunteers, over to you, Lani.
Yes, I was thinking about my answer. I think generally my personality, I don't like bullies of any kind. And whenever we have clients who have had some kind of violence against them, or even in a few cases, Nyla would remember me telling her about this, where we have a person who is accused of violence, but they actually haven't done anything. and how the court treated that person based on the circumstances. So I'm always interested to make sure that there is equal protection to both parties, and that any kind of violence in the household, find a way to stop it and use all of the tools available to me to make sure that those people are safe. I do think sometimes that it can go a little bit further, specifically where there is a possibility that somebody might need psychological counseling. I don't always think that we take that into consideration. We get the person out of the house and relatively safe, but we never talk to them about how they can be counseled, or how the children in the household might be counseled as well. So I'm always interested in seeing how we can develop and go a little bit further in making sure that everybody is safe in a safe household. And particularly over the last couple of years with COVID, I can just imagine what the kind of problems people might have come across where they haven't been able to leave, get away from the violence, or even just have a moment to themselves where they can reset and deal with whatever stresses that they're dealing with. So yeah, I think that's my focus and why I was interested in these seminars.
Right. Thank you so much, Lani. And perfect, because it ties in a few of the areas that I wanted to touch. And one of them being then the potential of the legal system, and throughout the region, or legislative responses have moved beyond the pure question of, okay, we need a protection order, but what are some of the additional questions that we might think of? What role for counseling? What are some of the other necessary support mechanisms that we might think about? And, you know, because I teach at the UE, and because that then is a regional experience, and for those of you who attended UE, then you know that we teach cross-regionally. It's always interesting to see not just law, and when we have great developments in the law, but also law in practice. You know, in the region we're at about, in Trinidad, we're at the 4th stage of domestic violence legislation. And in some ways, it is a bit almost disheartening, because having now achieved legislation that represents some of the strongest globally, how then do we explain the statistics that we see in the region, which tells us that this requires more than law? This is about implementation. This is about a societal transformation. And so even the best laws require us to do so much more work. And so again, why the work of Operation Safe Space and others like it is so important in making the transition, so that you'll see, and those of you who are before the courts engaging on behalf of clients, aware of the improvements in the Domestic Violence Protection Orders Act, but still, and in my conversations then with many of the advocates in this space, sometimes the extent to which A, attorneys are familiar with some of the new changes, and B, the judiciary, those are sometimes open to question. But then another part that Lani had mentioned was the question of COVID, right? And throughout globally and throughout the region. Now, what we do know is that there has been an increase in domestic violence and gender-based violence, and the legal system now is challenged to respond to that. So throughout the region, generally, domestic violence protection orders would have fallen on the list of urgent cases that should be heard by the judiciary, but we know that there's been a general slowing down of matters on account of COVID. And even outside of COVID, where you had you had orders that had applications that had been certified as urgent, and those applications having not been fully addressed, sometimes 6 months, where it really removes the teeth out of the urgency of the legislation. And so COVID now emphasizes the importance of this transformation, and also of both judges and practitioners being fully aware of the requirements of the law, but also the potential avenues for challenge. So thank you, Naila and Lani, for your comments. I know I called on you, so thank you for being very cooperative. So now we're going to be talking about a few things. Gender, a term that is now sort of entered into the ordinary conversation, but for which there may be some confusion. So you see the CEDAW, the Convention to Eliminate All Forms of Discrimination Against Women, referring to gender as socially constructed identities, attributes, and roles for women and men, and the cultural meaning imposed by society onto biological differences, which are constantly then reflected within the justice system and institutions. And so we're distinguishing between gender and sex. Sex, we're referring then to what's referenced here, the biological differences between men and women, but out of birth, there is nothing which suggests that boys will wear blue or girls will wear pink. There's nothing that suggests that boys are not supposed to be able to cook out of birth, right? Instead, you have these social roles that through the process of socialization, through the process of our schooling, education system, religious organizations, etc., there are roles and identities which are attached to the idea of gender, of what it means to be a man and a woman, and for which there are usually social sanctions if these are not complied with. So for example, if it is that a young girl is not interested in many of the usual things that are associated with femininity, then a range of questions arise from ranging from questions of sexual orientation, questions ranging to what type of woman are you if you're not interested in doing these things? How dare you not want to cook? Those sorts of questions, and all of those flow then from our understanding of gender as socially constructed. And the thing about gender as social construction is that it means that it is a process of development. It has happened over time, but it also means that it's open to intervention. It's open to new social constructions. And I like to use the example of masculinity and dance hall. If you listen through dance hall over the course of the last 20 years, 20, 30 years even, there are very clearly defined things that men did not do. So men did not wear tight pants, men didn't have dyed hair, men did not wear square mouth shoes. Then that shifted and Elephant Man's hair became multicolored, his pants became very tight. And so one of the things then is music and popular culture throughout the region is a space where gender is often then defined, policed, where ridicule. So if you happen, and I would encourage you just every now and then, hop on a minibus or ZR and hear a promotional CD, or go onto Spreaker and hear, just so that you're familiar with the scripts that remain a part of the conversation around what it means to be a man or a woman. Because these are very, very important points. And also then places where I think we can begin to challenge the culture, because for all of the music that I often hear, if I hop on a bus between Spikestown and UE, you can almost be guaranteed that you will hear about 10 prescriptions about sexual acts you're supposed to do or not supposed to do. But there's very little music about don't be a domestic violence abuser, don't be engaged in harmful activities. So then that our scripts around what it means to be acceptable men and women, that those continue to be developed through various forms, and music, of course, is an important form. So you would have heard me mention just now, for example, questions of a girl if she doesn't meet certain societal expectations. And so then we notice sort of binary gender expectation, where gender is then reduced to the social attributes and opportunities associated with being female and male, and to those relationships. But so in having this very clear, boys do this, men do this, what it does is that it is often producing inequalities when we look at the responsibilities assigned, who has capacity, who has resources, and who has decision-making power. Even in the context of Barbados, where we have high levels of women's political participation, when we start to drill down on the details, who sits on boards, who are, so in commerce, who's sitting on the boards, when we look at the state, the various state entities, who's sitting on those boards, etc., we see that even with the narrative, for example, that, and I teach mostly women at the UE, but that doesn't translate into necessarily into, for example, I'm looking at an interesting study seeing, before the Caribbean Court of Justice, of advocates, when are advocates likely to be women? When are advocates likely to be men? And there are significant gendered components of that, including, for example, if it is that, and my research has found that the majority of advocates appearing and being lead counsel speaking are men, and that women appear then in family matters, women appear when they represent the state, and so that means that that's a salaried position, and or when women are engaged in pro bono work. Whereas men, when leading in, say, public law cases and they're not state counsel, that's a state brief, and that comes with significant resources. And so even just the question of, well, how come men and women have, even though I'm teaching the majority of women, why isn't this translating into what we're seeing in final appellate advocacy, which is not a full metric, of course, where we see inequality. We might want to find out, okay, what's the underlying driver of that? And so that's a good example of, and that might then be linked to questions of, okay, is the culture and practice around litigation not conducive to then the caring responsibilities, etc., where we have not seen a full transition towards men being equally involved in care. What we know from COVID is that women's time, women's use of time is markedly different from men when we take into account who has responsibility for care. So who's taking care, who's making sure that homework is being done, who is actively sitting and doing the work with the children, etc. Very different. And so gender remains a site for which there is significant power that influences the way much of societal institutions are organized. So it happens at the individual level, but by it operating within then a system, that's where we see the inequalities associated with gender. So we covered this earlier, the distinction between sex and gender. We differentiate between biological sex and then the social roles or personal identification. And we will come back to these a little bit, but in terms of the terminology between survivor, you may find some individuals choose to refer to themselves as a person who has survived domestic violence, and others may use the terminology of victim. Survivor, when chosen as a self-descriptor, is empowering. It includes some form of agency, whereas victim refers to a person who has suffered, which then you see the shift in the active verb there and the object. So a person who has suffered harm directly caused by a criminal offense, regardless of whether an offender is identified, apprehended, prosecuted, or convicted, and regardless of the familiar relationships. Some victims, again, refer to themselves as survivors. And we'll just flag here that in the context of what we know of the data is that over the course of the Royal Barbados Police Force says that over the course of the last 5 years, give or take, that there has been a report of at least one incident of domestic violence every day, or at least the total numbers break down to in excess of one case for every day. But we know from the general research, and when we now move into sorts of surveys detailing women's experiences of GBV, that we have, then it is massively underreported. So if it is one every day, there aren't many crimes that it happening once every day that we don't treat it as a question of almost a state of emergency, right? And so we want to think through a bit about how do we attach that level of importance to treat to the phenomenon of gender-based violence as a state of emergency, requiring the sort of robust measures that we likewise have adopted in the face of COVID. So what then is gender-based violence? Gender-based violence is violence that's directed, kind of self-explanatory, because of their gender. So we've discussed gender. And it's important that, and I find in teaching gender, I teach gender and the law at the university, there's often then the question of what about the men? And we'll come to talk about that and why violence against women is understood as gender-based violence. Because, it's like, well, when you're talking about gender, you're only talking about women, and men and women have genders, and that's true. So how then do we come to this question of appreciating violence against women as a particular phenomenon of GBV? And so violence against women is an act of gender-based violence that, and you'll see a number of forms of harm: physical, sexual, psychological, economic harm. And these may be threats, they may be coercion, a variety of deprivations of liberty, whether in the public or in the private life, with significant then implications for how our societies function. There was a fascinating presentation just the other day by Pamela Cook-Hamilton, and talking about entrepreneurship. But how do we unlock women's participation in the economy? And in working with entrepreneurs, she's like, well, a key thing that we have to be able to address is domestic violence, because there is no space emotionally to be able to create and to be able to function. And of course, many women in the aftermath of domestic violence may use that as almost fuel. And so some women, after their experience with domestic violence, they develop businesses so that they are autonomous. But for the most part, what we do know is that gender-based violence, it deprives opportunity, it deprives the emotional space and freedom to be able to function in ways that best allow individuals to thrive and flourish. So that we want to understand this as a societal problem that has legal connections, but being able to see, what would a Barbados look like if we did not have that statistic that 1 in 3 women would be affected by a form of gender-based violence over their life course, right? What would that look like in relation to women's participation in the labor force, women's participation in entrepreneurship, etc.? It could be such a fundamental transformation because there are significant economic effects linked then to our failure to fully root out the issue of gender-based violence. So we've covered this. So why then gender-based violence and why violence against women is treated as a subset of GBV? And we come to the question of the experience of the reality that there are significant differences between male violence against women and female violence against men. When we look at the data from Barbados and throughout the Caribbean, we know that women are more likely to be victimized, they're more likely to have repeated victimization, they're more likely to experience significant physical harm, and they're more likely to be killed than their male partners being killed by male partners being killed by women. And so a part of it really is the disproportionate effects of violence against women. And in some jurisdictions, you'll see then the concept of femicide, where there is a defined criminal offense that speaks and treats to the question of gender-based violence as a particular criminal form. And that's one of the areas that, you know, we remain in deep thought about. To what extent do we treat gender-based violence as something so unique and anomalous that if a police officer saw two individuals where one individual was beating that individual in town, the police officer could arrest that individual, no questions asked, right? But less likely that you're going to see a criminal focus in the context of police officers being aware of an instance of domestic violence, and even the types of evidence that the police use, the reliance more often than not on the virtual complainant's willingness or unwillingness to bring claims, particularly where the system has failed individuals. It is a Herculean task to get them to trust in the system, to say, okay, you know, we should use the mechanisms available. And so when clients have had previous horrible experience with the justice system, because trust is so fundamentally eroded, then how do you get that client to say, you know, let me try it again? And so I'd be interested, for those of you with significant experience in the field, you know, what are some of the experiences you have had where the system has fundamentally failed your clients? You know, and have you been able to restore trust in the system, but for some of these individuals? Lani?
So I actually had invited this client to listen in on this because she has been so affected by the failure in the system at this point. Basically, what happened was she made a complaint. It was a series of different forms of violence that was perpetrated against her, locking her in the house and whatnot. And when she went to the police, she gave them all of the information as best she could, but they had broken up a bit before that. And because of the amendment to the Domestic Violence Act, the magistrate took the opinion that it could not be used, you could not use the Domestic Violence Act because they were not a former spouse or in a business relationship, but did not form the opinion that he could deal with it in any other way, like by assault or harassment or anything of the like. And basically made a bond that the two parties had to keep the peace between the two of them for 6 months. The issue particularly was that the overall claim ended up being dismissed because the police officers basically put the incorrect information in her complaint. So the dates that the police had put were not the correct dates that she gave to them. She wasn't given an opportunity to, like, what was in her statement varied from what was in the actual complaint. So if you looked at the complaint without looking at the statement, the dates are completely wrong. But if you looked at the statement and the complaint, then you realize where the error went. But the magistrate wasn't prepared to look at anything like that. He just dismissed the whole application for the protection order for those two reasons, and then made a bond to keep the peace for the two parties. And the person that she was bringing the claim against is significantly more powerful in Barbadian society than she is, and had made several threats in terms of affecting her in social scenes and whatnot. And what she did do is she went on to, like, basically make a huge kind of campaign for gender-based violence and advocacy, and she spoke out about it continuously, and her platform has grown. But while if something was like this were to happen again, I don't think she would ever rely on the police in Barbados, because she's not convinced that they will do their job properly, and she doesn't know what would happen depending on which magistrate she goes before. The reality is that, as Nyla was saying, depending on which magistrate you go before, some are more likely to listen, and some are more likely to just jump to a conclusion and say, oh, that's not that serious, or this person is not telling the truth, and that's the end of it. So I don't really have any way of convincing people to trust the system. A lot of times, my clients do not want to go that route, even if their life is in dire, it's very threatened. They don't want to go to the police. They don't want to do anything. They just want to try to move on and forget about it, which is unfortunate.
Right. Does anybody want to jump onto that before I add some comments and then continue on? Because this is also really useful. Trevi Green?
Yes, good afternoon to everyone. I'm taking it from a different direction pertaining to trust. I've had, well, very subtle but experiences with family members and friends who would have gone to attorneys and been abused financially. So before you go to the system to get help with whatever you have, and you're stuck, or you were unsuccessful at achieving what you needed to. So for me, my question is, where it comes to trust for the very clients, attorneys protect criminal attorneys, and when we know our colleagues are doing something that is inappropriate according to the law, and then persons are out there blaspheming attorneys, and Peter is paying for Paul and Paul is paying for all. So I would like, at some point, I'm hoping that the profession brings back some level of integrity to it, and what is being done about that where it comes to new and upcoming attorneys.
Right. So happy then.
Trust.
Right. So happy then that the Law Association is a part, the Bar Association is a part of this conversation. And a couple of things that I'll quickly address in terms of one, there was a point then, I'm not sure whether it's in relation to criminal activity. So I'm just going to clarify for my purposes that the importance of all individuals being able to access legal services, including those accused of crimes, is a fundamental safeguard. But equally, where attorneys are engaged in unlawful conduct, then the importance of the accountability mechanisms functioning in better ways to ensure then that trust is eroded in the law, equally when the judiciary fails as when attorneys fail. And so making sure then that a full system of accountability is in place is one of those things that's really important if we are to transform the culture of justice throughout Barbados and the region by extension. Returning then to Lani's intervention around the sort of unevenness of justice. So for those of you who studied equity, a significant part of the concern about equity was this idea of justice being measured by the chancellor's foot. And so, there should be a predictability about justice that, at least that's the story that we tell students, right? But that's the ideal of law, that it shouldn't matter which judge I appear before, because in effect, we end up hoping for a form of jurisdiction shopping, and we hope that we get the right magistrate, because otherwise the sort of temperament, the sort of approach that is in fact the fulfillment of legal duty. So this isn't a question of, oh, the magistrate is nice. It is that these magistrates are appropriately exercising their judicial function. And a very quick example then from Guyana in work that URAP would have done was where you would have seen the case before the Caribbean Court of Justice, McEwen, which is a really, really important case in our understanding of the potential of protection of the law, but also the idea that discrimination and substantive equality, that these are failures of substantive equality which find grounding in a constitutional breach. But in that case, having gone to a trans individual, having gone before the magistrate says, you need Jesus, you're confused about yourself, etc. And the Court of Appeal did not find that that had been an actionable and justiciable question at the level of the Court of Appeal. And the individual said, I'm not going back to court about this. But instead, they initiated a complaint against the magistrate, which resulted in sanction. And so around the question of accountability, this then requires some creative thinking on the part of attorneys, even, and I acknowledge this, against the tide of accountability mechanisms that do not always work, but they will work better through more use, through more robust challenging and chronicling of their failures, because I think for many persons, A, they don't know that they exist, B, they're not aware of the failures. And so we in the profession then also have a duty to be able to disclose these, because these are the things that are important for law reform. These are the things then that maybe ought to inform the conversations that we're having about what type of constitution we want to have if we're in the process of reform. And so, think about some of the things that we're thinking here. How do we better frame gender equality in the context of potential reforms, so that we're using every strategic point of intervention in order to strengthen the position of those who have been made vulnerable in society. And so I use the expression made vulnerable because vulnerability is not an inherent state. It is the social relations, the products of the environments we have built, etc. And so you see that even around language and disability, a person with a disability versus a disabled person, where it is the social barriers that are often the cause of exclusion. So coming back then to gender-based violence, what are some of the forms of GBV that are protected under the legislation, under the Domestic Violence Protection Orders Act in Barbados? This is an easy one. Anyone, quickly. What are some of the forms, and what were some of the new additions in the 2016 amendment? You're going to make me go back to the chat. My participants list. I'm going to call, there are three other people who share my last name. So I'm going to invite one of the Brathwaites who may have had one more than the other two may have had some role in drafting and guiding that domestic violence protection orders amendment through Parliament. What are some of the areas that are protected under the legislation in Barbados? So I'm going to call, okay, I see it unmuted. Yes.
I know you were referring to Mr. Brathwaite Sr., which would be Adriel, but Shane Brathwaite would take the question.
Good.
We had under the old legislation, we would have dealt with the normal physical abuse, harassment, threats, things like that. The amendments which Mr. Brathwaite Sr. would have sought to amend would have extended it to emotional abuse, it's included financial abuse and stuff like that.
Right, excellent. Right, so we see the categories of GBV, so they're physical, battery, sexual assault, rape, etc. Economic, so denying Lani would have made the reference to the threats to employment or just social standing that come with economic consequences. Then there's the psychological, the emotional, and then increasingly in the context of a digital environment, the extent to which we're fully grappling with the online dimensions of GBV, including non-consensual pornography, which is perhaps problematically referred to as revenge pornography. One of the areas that we may need to give greater thought to, even as there is the legislative framework dealing with threats in the online environment, specific treatment of this. And in Trinidad, you would have seen the case of Therese Ho and Lendl Simmons, where through a civil claim, the court would have sought to develop as much as possible within a civil context the scope of protection of privacy. And in the context of Barbados, then we want to think about, to what extent does the formulation of privacy that we have in our constitutions give ground for addressing this form of privacy in terms of informational privacy. And again, one of those areas that we might begin to think about robustly as we enter into conversations surrounding reform. An excellent, Joan, child abuse as an offense. And what's important here is, and we'll see later, the relationship between child abuse and GBV. Right, so we now then move on to, from the literature, what are some of the causation risk factors associated with GBV? Actually, we are fully an hour in at this point, so I'm going to give you a chance to take a brief 4-minute break. So we'll be back at 3-minute break. We'll be back at 6:35, and then we will continue on. So I will grab a bottle of water, and I encourage you, although it's just me with my camera on, so all of you can walk around, etc., to stretch your legs, to do whatever you can in the next 3 minutes. And we are back. And we will now move into the second component of our presentation. So we had last flagged that we were going to be looking at some of the causation risk factors associated with the GBV. And this is then broadly supported by the data, even as we appreciate that GBV has no, GBV happens at all levels of society. There's a way sometimes that I think there's a broad discourse around GBV that it is restricted to particular strata of society, and we know that to simply not be true. But the literature, and again, my role here is to talk a bit about understanding the gender dimensions, etc., and less about the specifics of the Domestic Violence Protection Act, Orders Act, and other legislation, because that will be dealt with fully in this component. I'm really laying the foundation for us being able to think through the fullness of some of those components. But useful then for us to have an appreciation of some of the data points that have emerged through the studies. And so we know that masculinity is a significant part of this conversation. So where gender roles are rigidly defined and enforced, and masculinity, what it means to be a man is linked to questions of toughness, dominance, etc., then that's a significant predictor of domestic violence, of GBV. What we know is that those who've witnessed intimate partner violence at home, experienced abuse as a child, where there was an absent or rejecting father, etc., that there is a significant relationship with the likelihood of being a perpetrator. But again, always highlighting that this is the broad data. This is not some predictive scheme that if you see all of this, this is what this necessarily means. But those who've witnessed intimate partner violence, experience are also, so then you see that relationship between experience of GBV with likelihood of perpetrator, but also the relationship with likelihood of victimhood. And so we see this in a regional study produced in 2018. And the study found that where the man controls wealth and decision-making within the family, and there's significant marital conflict, then there is a higher likelihood of GBV. It equally found that where violence was normalized, and that as a society, when the society tolerated physical punishment of women and children, and again, seeing the connections and the linkages, because part of the reason why I'm an advocate of changing the way we address the ways in which children are disciplined is that there is this relationship between child punishment, particularly physical punishment, and its relationship with GBV. But once we found that as a society, there's a normalization of violence, and there's an acceptance of violence being used as an appropriate means to settle interpersonal disputes. And when we think of some of the language we use to talk about relationships between men and women, or understandings of how we talk about sex, who gives sex, who receives sex, etc. Those are significant because they sometimes point to these questions of ownership, etc., which are intensely then problematic. Lani says that it might be useful to have more training for the first responders, and after the women and children have left the perpetrator's presence, to have counseling for them so that the cycle is broken. And true, again, part of the necessity of a whole of government, a whole of society approach, because we have to find all of the points of interventions. So when we think of a child who is seeing GBV at home, what does this look like when that child goes to school, right? How does that child, how am I supposed to be able to focus in school when I have seen something so harrowing the night before? And I'm supposed to sit and be well behaved, and I'm supposed to focus on math, and I'm supposed to be interested in long division. Of course, there's a disruptive effect. And so then seeing those connections, really, really important. So we see the causation and risk factors. Individual, there's a where an individual has been a victim of child maltreatment, where there's a psychological or personality disorder, where there's alcohol and substance abuse, and a history of violent behavior. And one of the things that, again, and in one of my other lives, I'm particularly interested in public health. And we have to begin to treat gender-based violence as a public health imperative. The level of health effects linked to GBV and the economic effects are so substantial that we have to begin to treat to these issues as public health questions. And in Jamaica, just the other day, the DPP, Paula Llewellyn, made a similar comment that we have to begin to treat gender-based violence and child abuse as a public health threat, because it fundamentally undermines the well-being of citizens. And so, how do we begin to address the culture of alcohol and substance abuse in Barbados, where, if you are like me, and I've seen some of you down Spring Garden before, so I know that some of you are like me, then when we think about Kadooman, when we think about that blissful period between May and August, just the amount of songs that are fundamentally about drinking, right? That isn't a sideshow to the high level of alcohol abuse that we have in the region. And again, we come back to the point of music as, and this isn't blaming music, music is often reflecting, but music is also an amplifier. So how then do we get our artists to have varied conversations, for example, around alcohol? There are a few songs, because there's a praise for a song that encourages not drinking and driving, for example. But we know fully, and we know it fully because when around every 4-5 years, give or take, when artists are engaged to do political jingles, they use the same songs to develop much more substantive lyrics about a whole set of substantive things. Now, of course, in the middle of a party at 1 a.m., you're not necessarily trying to hear about social issues. And there's a place for the feel-good music, but that feel-good music plays the whole day. And so, how then do we see these connections between the ways in which our art forms, the ways in which our, the rum shop next to the church sort of discourse, how do we see those as linked in this conversation of GBV? And then there are a number of relationship factors that are relevant risk factors. Poor parenting practices, marital conflict, violent parental conflict, low socioeconomic household status, and then a culture of friends engaging in violence. And so this comes back to, there's a very well-developed programming approach to a Ministry of Family in New Zealand, because so much of our societal challenges are linked to, there's no manual on parenting. Parenting happens as often as a byproduct of a way too good night, and not necessarily planned. And so then with no guidebook for parenting, of course, then we see increased poor parenting practices, etc. But also a broader question of our ability to engage in appropriate interpersonal conflict resolution. And Lani's absolutely correct. How do we as a society engage in accountability? The accountability, the ordinary everyday accountability of calling out bad behavior. And we would have seen, and with shame, the story of the journalist who came to Barbados for the remote worker, the remote visa program, and left because the experience of catcalling that for many of my friends, just like, it happens, was such a shock to the system. And, there are ways in which people who are exposed to violence repeatedly, that you become normalized to it. You become numb to it. And so that inability to have accountability at various levels, they represent significant risk factors for violence. Then there are a couple of community factors and societal. So again, the importance of programming that addresses poverty. What governments are doing to address poverty is not just and I think, sometimes we treat this as a question of, well, this will be a mechanism for votes. You want for the employment numbers to be low, even if artificially so. But our inability to develop, in some cases, I think, much more robust social planning mechanisms to address poverty, crime, unemployment, drug trade, etc., that those then are significant factors that point in the direction of high levels of GBV. And then finally, on a societal perspective, where there's rapid social change, and if you remember some of the debates of the 2000s, where there was a sense in which, and at least the story was, there was a zero-sum game of women were ascending and men were being challenged in their place in society. And so those rapid social changes, gender, social, and economic inequalities, those lead to perceived grosses almost, which then can translate into risk factors for GBV. Weak economic safety nets, poor commitment to the rule of law, and cultural norms, those are all then significant risk factors. And so, sometimes it really is that we treat to the law as the solution, where all of the risk factors that we're looking at, these are social programs, these are social programming requirements. And so, it's an area where I'm always curious as to what is it that we want from governments and governance about issues of societal, of social reform, of poverty alleviation. How do we address these in meaningful and robust ways? Because this is not just a question of the unemployment numbers, important though they be. These are also then linked into these broader conversations around gender-based violence and other forms of harm. And so just to bring in an intersectional lens, we know then that vulnerability, or what I refer to as vulnerabilized condition. So you're made vulnerable, you're not born vulnerable. But we know that children, the elderly, people with disabilities, that they're more likely to experience abuse. And I recall, I want to say maybe it was, Joan, who was specializing in elder law, that the vulnerable status then means that there's significant sections of our population that are then more vulnerable to GBV, because abuse is fundamentally a question of power and control, especially where that is then linked to low mobility, to low access to many of the things that we take for granted in the everyday. And then there's also then a relationship between GBV and HIV. And fundamentally, this comes back to a question of gender inequality, because we're talking about the inability to negotiate safe sexual relations. And so if you are entering into sex in a position where you do not have bargaining power, then of course there is the inability to decide, well, I'm using a condom or not. This results then in many forms of violence, both inside and outside of marriage. And then, of course, the work of enhancing our HIV prevention, et cetera, programs all of this is telling us about the deep and meaningful connections. So just checking in very quickly with you. True or false? Sexual violence is more likely to be committed by a stranger. Is this true or false? Feel free to pop it into the chat. False. So they're two false. I'm beginning to think that some of you are not telling me the truth, because how else would we explain the often repeated calls for the first sort of response to violence that at least I see when I engage Twitter is, we need a sex offenders registry. And that flows from the idea that sexual violence is more likely to be committed by a stranger. A registry does not solve the problem that we know that it is uncle. It doesn't solve the problem that it is a friend who very well may be the individual most likely to sexually violate. Nyla?
My only concern with that statement is that I think these people become trusted. So, uncle, you may not know uncle, but you meet him, and then, so he may not be a blood relative. He may be somebody that gains your confidence. So I think there's room for both ideas.
Right, so I'll just push back a little here, because I think the risk of the sex offender registry, and this has nothing to do with this conversation, and this is just my personal position, but somewhat supported by empirical data, is that they often then function as this is the solution, as opposed to the types of things that we're talking about here, about enhancing access to justice as a first necessary mechanism. Because if we have a case where you're going to be in the sex offender registry if you are convicted, and the effective state of or low levels of conviction is that many of these sexual crimes are crimes without, are essentially almost decriminalized to the extent that there's a high level of impunity. But point taken, Nyla, just my sense of the data is that they don't directly address that the most of the violence happens within the spaces of trust, where frequently, and what we see in much of the data, so there was a fascinating study in about 2014 on attitudes, perceptions, and opinions surrounding child abuse. And what we see in the data frequently was that it was raised in the family, but there was often then a protective sort of, well, not uncle, not etc., where the registry doesn't solve that. So domestic and sexual violence are the only types of violence affecting women. True, false, maybe. This one is an easy false. And then violence only affects certain groups of women. So this is not a question of wealthy women. This is not a question of women with, degrees. If you have your PhD, violence doesn't affect you. Again, false. So now we want to, having laid the foundation for some of these understanding causation, risk factors, what we mean by gender, the question of power, we now want to ask, law, what is it good for? What are we going to be? Why this focus on law as a space for intervention? Yeah. So we want to think, what are some of the international treaties that address gender-based violence? What are some of the laws that are relevant to what we are thinking about here? Feel free to pop a few in the chat. Feel free to unmute if you wish to. What are some of these laws and treaties that might be relevant to us? And then as a follow-up question, for those of you actively arguing or studying our judgments before the courts, to what extent are our courts receptive to the uses of international law? So have any of you had any experiences where you've attempted to use international law and the court said, that sounds good, but not really relevant to my judgment? So Lani says it depends on the judicial officer. Most of the time, insular not interested in external laws. And what I can tell you is that there are I want to say that there may be 3 judgments across the region that reference the convention, maybe 7 now. About 3 years ago, 3 judgments that reference the Convention to Eliminate All Forms of Discrimination Against Women, which is one of the treaties and the sort of preeminent treaty that addresses gender-based violence and which has significant and powerful recommendations for what the state ought to be doing. And more importantly, not just recommendations, obligations that the state has agreed to. And what we will cover a bit more on Thursday is the idea that international law is not now to be treated as some far off thing out there. And instead, because many of these concepts do not have local expression in our legal frameworks. So, we signed the treaty and we say we have signed the CRC, we have signed the CEDAW, the CRPD, we like to sign treaties. How then we translate those, and of course it's a question of resources, but resources are also a question of political will. How we translate that into domestic law and policy are significant areas of weakness. And so these various international treaties, they're useful for us because they can help to spell out the duties of judicial officers. They can help to spell out the duties of the police, the duties of the various stakeholders who come into contact with or as a part of the judicial system, but the various points of potential failure for a victim or survivor attempting to navigate this system. And again, let's think about our judicial system. Our judicial system is it is individual. So more often than not, you have to have the ability and the sort of legal know-how, right? So I have to know that this raises a question that I should see a lawyer about. This requires then that I have the financial ability or legal aid, and I can wait on legal aid process. Right, so starting international is no help. We'll come back to this. I would suggest then that there is a very valuable role, and that the role of the Caribbean Court of Justice and the types of judgments that we have for the first time in the last 5 years about the uses of international law, that what is necessary is a concerted and strategic effort at accountability using those so that magistrates and judges are aware of their obligations. And of course, entities like the Jurist Project, etc., are really, really helpful in helping us to develop the policy and implementation frameworks. Because again, we've done the judicial training in some cases. It's not for judges attend trainings on GBV, police attend trainings on GBV, but when does that translate into something fundamentally different? But we can also raise questions about how do we make sure that the magistracy is representative of the type of judicial officer going forward. So some of the international law frameworks, the UDHR, the CEDAW is the one that we'll be focusing on. Declaration Against Violence, we have the Belém do Pará Convention, the Beijing Platform for Action. And you'll just see, I'm engaged in a study currently that's looking at what are the obligations that flow from the state's commitment in international law to address gender-based violence. And in some cases, we pass the tests. Does the legal framework target domestic violence in clear ways. So do we have acts which may constitute? In some cases, yes, most of them, these are covered post-law reforms. Is the legal framework adequate for enabling married and unmarried individuals to obtain non-molestation orders, etc.? Does it cover as many individuals as it ought to? Are there adequate mechanisms around questions of compensation? There are a number of questions that the international frame is useful for us to think about points of strategic advocacy, but also then around the questions of what obligations should we be then utilizing in thinking through the question. Yes. And so you will notice here, if we come down to the training of state officials, does the legal or policy framework require mandatory and comprehensive training for police officers and judicial officers who deal with individuals who have experienced domestic abuse? And so I'm seeing in the chat that our officers need training. And so we have to have a robust and mandatory requirement for greater forms of training. Because, and the magistracy, I think oftentimes sort of, particularly external partners, they come in and they think, we need to have an action that's at the level of the High Court. Whereas the magistracy is where most individuals experience justice or injustice, whichever it is that they experience. And so we need to then be in the position where this is a part of the international obligation. So they created essentially, right? And so again, Lani, one of the questions is the adequacy of funding. And what's important here is that we see for the first time throughout the region, for example, the absence of rules, for example, of courts newly developed to address some of these things, have been found to be a violation of constitutional rights. The inadequacy of funding, etc. You can't tell me that 2 officers is supposed to be the complement. And those are the sorts of things where once we've noted the inadequate failures, what we usually say is, the system isn't working, as opposed to, well, is this a mechanism through which international law could allow us, rooted in our constitutional expression? So, we do have these rights to non-discrimination. We do have this right to equal protection of the law. And if equal protection of the law, and a fascinating judgment from, there are 2 judgments that I will send to you after, the Opuz judgment from Turkey and the Cotton Fields decision from the Inter-American Court. And those judgments are fundamentally about these sorts of questions, about what happens when the state does not put enough resources in place to address some of these things. What happens when you have police officers who refuse to do the adequate due diligence, etc. The idea then that there is an obligation of due diligence is a significant and important one. So we're almost now we are at 4 past. I'm going to wrap up in 5 minutes, and then we will open for questions. If there are not many questions, there are a couple more slides that I can go through, but it is important that for some of the things that we've covered here that we do have some conversations about. Right, so international law framework, why this focus on international law? It's a tool for rights holders to hold states accountable. It enables individual level responsibility and systemic level responsibility. We're in what we're hearing and what I'm seeing in the chat, which is consistent with much of the research, is that we know that the system is failing at parts. What does accountability look like? How does this bad behavior find judicial recourse? How do we think through the various strategic points of intervention? And I'm not suggesting that litigation is the sole source or that even litigation is the best source. In many cases, litigation is possibly the worst source, especially where the outcomes, for example, might be that you have strategic litigation, the litigation fails, and then you're 10 years behind, right? But good strategic litigation and good strategic engagement. So the idea of strategic engagement is much harder work. is much more of this type of work, of engaging with Operation Safe Space and advocates who are on the ground, and then connecting for a pathway where we identified, well, there's 7 points of intervention. 2 of them are the ones that we use as a last resort, but these are the points of engagement, etc. So I'll wrap up on, there are 3 more slides actually, and then there's a lovely slide that says that's a wrap. So in our domestic context, then we know of the duty of non-discrimination, the right to the security of person, to protection of the law. And when the CCJ says provocatively, I think, that protection of the law, it is a rule against arbitrariness and unfairness. And when the CCJ says that protection of the law imports an obligation to comply with the state's international law obligations. And in the Mayan Alliance decision, and I'll share these with you after, in the Mayan Alliance decision, you had this case from Belize where Mayan land tenure had never been protected in Belize's legal system. So there was no system that recognized it. There was no law that covered it. It was simply a state of failure. And there are a number of kind of interesting background facts that we don't need to concern ourselves with too much. But suffice it to say that having not provided tenure, having not recognized the proprietary interest, a claim was brought before the court on this idea that the absence of recognition, that the absence of appropriate mechanisms was a failure of protection of the law. And what was interesting about that was that at the time, and Justice Morrison, who then he was a judge in Belize, but later was the president of the Court of Appeal in Jamaica, if my memory serves me correctly. He wrote the Court of Appeal judgment. He said, access to justice. How can you claim that you don't have access to justice? You brought your case here. We said that there was no breach, but the ability to come to court was the limit of access to justice. And then the CCJ comes afterwards and says, no, that is the barest idea of access to justice, that a meaningful concept of access to justice and the protection of the law, that now imports questions of resource allocation, that imports questions of duties to comply with your international law obligation. Now, it's not a model that will work in every case, because what you have is years later that the CCJ continues to monitor the judgment, the enforcement of the judgment, where there were several positive obligations that the state of Belize had to take. But what's interesting about that case is that there were systemic remedies. Those systemic remedies were enforced. And the reality is that for the most part, we don't have a culture of judges adopting systemic remedies. Now, a part of that is also that, I don't see my research tells us that many of these cases where we have failures, that we don't say, okay, well, the judge did foolishness or the police did foolishness. I can't do much more because that's the limit of my powers. What we see where there have been these types of challenges is that it slowly, and very slowly, I will admit, brings about a slow shift in culture, in the cultures of accountability, in the cultures of the ways in which judges function. But the idea of a systemic remedy, that having had that magistrate that failed, and having had that police officer that failed, and then a court requiring, as a part of a judgment, that police officers must have have continuous professional development around GBV, because it is such an important part of their work, right? Because the sort of pushback to this is, well, police have so many other things that are important for them to do, and magistrates, how can we require them to have training on GBV, etc. But when we think of the volume of work before the court, before the police, that involves these questions, and when we think of the states, and this is important to highlight that in family matters, this is one of the areas where women are disproportionately affected by uneven access to justice. So in the other areas, that's not where what the literature demonstrates is that's not where the greatest need sometimes is for women's access to justice. But that sort of systemic remedy, I think, would be transformative. So, yeah, so I'll stick a pin here until we come back on Thursday, and I will share then with you some of the judgments that I mentioned in the last salvo. I will go into depth a bit more around, you know, what are some of these judgments that have been emerging from the international space? What are the possibilities of international human rights law? What are the limits? Where, you know, how do we get a magistrate to be attentive to their international law obligations? How do we get the Chief Justice to develop specific protocols covering this? You know, there's a gender equality protocol that has been developed in Belize and in Trinidad. And it was so interesting. And I think maybe Lani had mentioned it earlier, where we have a magistrate that tells women they should not have children if they can't support themselves. What the literature and research found is that many of our judges have very harmful views about stereotypes. When we come back to CEDAW, and CEDAW says that there's an obligation on the part of the state, is in relation to harmful stereotypes is an obligation to address them, right? And point noted, Lani, read the absence of reported judgments, again, because it's happening at the level of the magistracy. In some ways, for those that are appearing before the High Court, justice, etc., carry law have been, so there are more judgments now. And, you know, as we change some of the ways in which we have treated to parts of the judicial system. So there was a really, really interesting judgment from Trinidad where it was a sentencing judgment for an individual who was convicted of sexual violence against a minor. So he was 19, maybe, a pan player, and she was playing pan. She was 13, maybe 12, 13. And the judge, you know, sort of inelegantly moved around some of the issues. He would have referred to her as precocious, for example. But what he said was that the role of the law is to protect even precocious girls from themselves. And so there is no way that this individual would be able to claim some sort of credit in around mitigation, etc., because of some of the facts before the court. But as we move then into the culture of sentencing judgments, as we move into reforms around the judicial process, there's also hope for some of these things to come to light. And a final judgment that I will share with you around the question of provocation, a judge in Trinidad, a very powerful judgment where the idea of adultery as grounds for provocation was so firmly rejected that these are little hints of, little sparks that give me the occasional pause to think that maybe we can go in a new and different direction. So now we are open to questions, comments, interventions. This is as much, very much a learning experience for me as well. I'm engaged in research around the area, so it is always good to hear from practitioners and those who experience the system through different entry points. Any questions, comments, interventions? So because I recognize Chapter, I'm going to ask Chapter whether there is anything that he wanted to add. How does the law handle women who lie? Interesting question. We'll come back to that in a bit. Talal's question first. Can we expand on exploring training of officers and the magistracy? So perhaps, Talal, this might be a useful, if you can expand on the question, then we can expand on the response. And Lani, okay, sure. So Talal, I'll respond to Talal and then to Lani to respond to Japter. If you're not able to use your mic, Talal, then feel free to private message me.
Yeah, so sorry, I was talking with the mic, with the mute on.
Right.
No, I appreciate this seminar. I think it's very informative and it's good. It's very good, and I'd like to see more of this, especially coming from the Bar Association. I don't really have a question, but it's more like, you know, we heard Naila speak about a certain matter, and I'm not going to go into that. You know, it's still before the courts, but how do we get officers and the magistracy across the board to just, how do we get them to work with people? Because every time we get a matter, we go before the courts, protection order this, protection order that, you know, and it's completely failing, if you ask me.
Right.
So how do we do it? How do we get it better? How do we get them to understand? You know, because sometimes we go to court and the attorneys across the board could appreciate this. You have magistrates that just fail us, either if you're representing the complainant or the respondent.
Right.
You know, so it's like, how do we do it? How do we get it better? Because it's not
Right.
good.
So again, I think like this is one of the areas where there are a couple of points of intervention surrounding the magistracy. A part of it is something that the bar can lead on, where if we want to change the culture of judicial education, of legal education, then compulsory professional legal development, continuous professional legal development, as is in Jamaica, that's a potential avenue that says that there must be, that, you know, the Bar Association takes seriously and the commitment to continuous development. And so attorneys are continuously going to be doing this work. Because we also have a thing, I think, where a part of the challenge is surrounding, sometimes as attorneys, we're conservative, so we don't make the big, bold argument because this judge is never going to be able to engage with this. This is requiring too much. And so sometimes we use the safe arguments in the first instance. We do have the benefit, and I know so many attorneys are in some ways, and I'm fascinated by particularly my young graduates who, I'm like, what are you using for research? And just the limited legal access to legal resources that some have. I'm just like, I'm amazed at anything because, you know, how are you able to bring cases, etc., when you don't have access to any of the major search engines, etc. So that's one thing in terms of, okay, how do we begin to signal a change in the legal culture? Then there's a question of, in other jurisdictions, there have been a sort of revisiting of the appointment of magistrates. What are the requirements for a magistrate? And then once appointed, you know, what is the requirements for training? So those are some of the points then where, you know, it is not the Domestic Violence Act that we might need to focus on. Instead, we go back to a more base position of how do we ensure that, and I say this all the time, that personnel is policy. And so how do we ensure that appropriate individuals are at the place where people most often encounter justice? It isn't the High Court. It is, for most people, the magistrate is the only place that they will see have that formal engagement with the justice system. And then just to conclude, you know, we do have projects like Juris who've been doing work around GBV in Trinidad, the development of new specialized courts. And there's always a risk of specialized courts Will they be adequately resourced? What happens when you take matters that were being heard at 10 courts and you have one court dealing with it? Are there efficiency gains which are lost? So there are a number of considerations, but I think what we have as a fundamental starting point is the belief in the potential that our systems can change. And once we believe that, then the mechanisms, the funding, all of those things are subsidiary questions that we will have to cover. But none of that is possible if we don't have that first fundamental belief that there is a need for change, and B, that change is possible. I'm happy to engage with any entity that wishes greater training in some of these areas. And it is and let's say even in some of the cases with the High Court, where because judges may not necessarily be representative samples of the population, even I remember a friend of mine was discussing a case, and her client had used an expression which I was well familiar with because of my background, but the judge did not take that expression as an expression of sorrow or regret. And instead, the judge found that as a sort of aggravating factor, the absence of remorse, whereas the expression that had been used was one that conveyed to me some level of remorse. And so that's another area where what the studies tell us in Trinidad, we need these studies in Barbados, but it'll be an easy study, is that concentration of judges from particular backgrounds, that can have particular effects on meaningful access to justice. So that's a bit of a fulsome response. I'm going to let Lani respond, then I'll read Anya's response, and then I will jump in. Lani?
Yeah, what I was going to say to Japter is, I think instead of saying when women lie, what should be the response of the judiciary when individual lies? Because I've been on the receiving end of both genders and people lying about a case or something that's happened to them. The reality has been, in my experience, even when you have it's been proven that somebody's been dishonest in their testimony or something that they have relayed to the police officers or the magistrate is less likely to do anything about it. They will either agree to make the order or not to make the order. And I would think at that point, it would be a situation for the individual to see if you can carry it any further. The magistrate does have the power to deal with perjury, and because you have to swear the affidavit in order to get the original application before the magistrate in the first place. So if your application is founded on a lie and it's proven during the trial, the magistrate can do that, but they don't. I don't know if there'd be any real benefit if they start doing that. When you start talking about imposition of fines and sanctions, the problem is a lot of times, because lawyers are so very good at eliciting information from people, and people sometimes they're not lying, they're just maybe not understanding the questions properly. It can appear as if someone is being untruthful when they really are not. So I don't know that it needs to have such a heavy-handed approach, especially if it's a situation where there's a less educated person who really does need the intervention of the court and some kind of protection, who may not have had all their information accurately just because of years of abuse or whatnot. So I think it really should be up to the magistrate to exercise discretion and deal with them. And I have been in court where magistrates, they may not have imposed a sanction or a fine, but they well cuss the person and criticize them immensely for whatever they said, sometimes, in my opinion, unfairly, but this is what happens.
Right. And Anya said, Jack asked a good question, sanctions inclusive of fines, and I would even say imprisonment, depending on the circumstances. Now, of course, these are the natural sanctions associated with perjury, right? But the question Anya asks is, what happens if the lie or embellishment is in the victim's mind, the only way to escape the abuser? And so there are a couple of dynamics that I think we have to think about with a question like this. And so I like to talk within context. And what we do know is that gender-based violence disproportionately affects women, and it is severely underreported. And so the question, I'm sure, Chapter, my reading of the question is that it wasn't then almost fundamentally presupposing that women as a majority lie, right? And so you're asking the question of the case of, okay, what happens when there is a false accusation of GBV? And so the sort of ordinary process is that a court may not make the order, for example. And then where it is that it is appropriate for defamation to be taken, etc., that those are some of the natural routes and other legal routes for consideration. But it is important then that this sort of engagement happens within the understanding of A, the context of GBV, B, the question of power relationships, of power relations that are defining the broader circumstance of gender equality and inequality in Barbados, and then the specifics of the individual case before the court. If we start at the individual level, I fear that the context of much of the discourse is missing, and so years back there was the idea then that and I'm drawing a parallel here, I'm not suggesting that this is what Jepter was suggesting. The idea then that every birth should be met by a paternity test, right? Where the essence of the suggestion was that women are, at a broad rate, lying to men about paternity, etc. Whereas a more targeted solution was that it should be accessible where an individual wishes to challenge paternity, for example. Those are two different positions. One starts from the fundamental premise that women are dishonest, and again comes back to many of the stereotypes and harmful gender stereotypes that are embedded in societal discourse, but then also make their way harmfully into judicial discourse. The time now being 7:28, I'm going to hand over to Robin directly on time.
Yes, you did perfectly. Thank you so much, Rashad. This was extremely informative, and I think we all agree that a very necessary conversation took place today. So just kind of a quick housekeeping note, the format will be the same on Thursday. You will receive the invite to register to receive the meeting link the morning of, and we look forward to seeing you then. And if in the meantime you have any questions or want to reach out for more information, feel free to email operationsafespace.bb@gmail.com. Thank you so much, everyone. Looking forward to seeing you on Thursday.
Very quickly, if there are any questions that you would want me to cover on Thursday, feel free to send Robin that note, and I'll be sure to tailor the presentation to cover some of those questions that may benefit from a little research, for example, on my part.
Thank you, Rashad. Thank you all. Good night.
Good night, everybody.